Morning, Mr. Stevenson.
Good morning, Your Honors. My name is Charles Stevenson. I represent the defendant, George Johnson. The case is before the court on a reservation and report, the question, substantive question being an Acevedo error in the trial judge's jury instructions, the more esoteric question being whether indeed this is a new and substantial issue. I would suggest that though a matter that this court addresses with some regularity, in this case there's a particular twist, and one that I would say hews very heavily in Mr. Johnson's favor. In the most literal sense, this is not a new issue. Mr. Johnson, his case was decided some 5 months before Acevedo. In fact, he made a very, I would suggest, clear and credible argument that the jury instructions on provocation were constitutionally deficient. This court, in the person of Justice Freed, essentially.
But is your argument that the court, in the person of Justice Freed, didn't really reach the issue, or is it that it reached it but got it dead wrong on the record in this case?
You know, it's not totally clear to me with what exactly he did, because there's something that suggests he somewhat misunderstood the question presented. It's that Mr. Johnson is asserting that the judge was not clear about the apportionment of the burden of proof, and then goes on to say, but he said twice it's the government's burden to prove beyond a reasonable doubt that there was no adequate provocation in this case, and that's simply wrong. I mean, it's actually totally wrong, because the only real iteration is a dead square right on Acevedo. It's the government's burden to prove provocation. Then later on, he does say that it's the government's burden to disprove provocation, but then he fumbles the ball. You know, he's heading toward the goal line there, trying to make an Acevedo or a Fickling sandwich of correct and incorrect, but says, and the government must also prove that there was adequate provocation, or that there was a causal connection. Thank you.
Was it dead wrong at the time?
Well, of course, that's one of the big debates, and a debate that Your Honors are going to have, because on the one hand, there are those cases, Smith being one of them very recently decided since I briefed the case, that stand for the proposition, Boucher, it was foreshadowed for some 5, 7, 10 years, whatever it is, because, of course, that case had correctly stated what the burden of proof should be. On the other hand, and of course I rely on it rather heavily, there are a number of cases, but LePage being sort of the marquee one, saying, hey, you know what, no big surprise that no one has been objecting to these at the trial court level. It's the standard instruction. There's a suggestion there, I would suggest, that this court recognized, oops, you know what, we've been fumbling the ball for some period of time too. And ultimately it really is a rather metaphysical question, because it was foreshadowed. But here's Mr. Johnson having made the exact argument And this
You're not going
court,
to tell us what the metaphysical question is.
well, I guess it's,
Should an innocent man go to jail?
well, and innocent to a degree, because of course we're talking about innocence perhaps of murder versus manslaughter. But the Robert Frost question, you know, if the tree falls in the forest, but the court doesn't hear it, was there a sound? And the sound being, is this new, is it not? And, you know, it really is very difficult. I mean, I totally understand that finality is a legitimate value. I would suggest that amongst us up here, we'd all have 10 different lines at which we would draw the sort of fairness, finality line. And you know what? Mine may not be right, but I'm very comfortable that this case is so far on the fairness side that though it may be rare, conceitedly, that an issue that comes up in this situation should be reviewed again, this is that case. It absolutely is, as I said, a four-square acevate. This is not a sandwich.
Well, excuse me, but don't we have to conclude that Judge Freed committed an error?
I can't recall whether it was Justice Hennessy, then Chief Justice later, who wrote the Raposa case. But you know what? I mean, somebody on this court made a mistake in whatever it is, Melendez-Diaz. I mean, it does.
That was me, probably.
A metaphysical question.
But you know, you are human beings, and 7 bright, capable, highly trained and experienced people. But mistakes happen, and this was a mistake. And I think the proof is the little paragraph that Justice Freed devotes to this issue compared to Acevedo, LePage, Roderick, all the various cases that were decided in that 4 to 5 year period immediately thereafter. I mean, this was painful stuff. It was very, very closely analyzed in a number of ways, none of which happened here. It just didn't happen. You know, in terms of, if I can sort of segue into the merits, I mean, I think there are 3 questions the court has to answer. First of all, was he entitled to the instruction? Well, it's unanimous. I mean, I think I have to throw that back on the table. I can't be here asking for remedies without saying, well, you know, you have to decide whether he was entitled to the instruction. But it is unanimous. Trial judge thought, DA thought, defense thought, and it was a point that was argued even in the defendant's opening statement. And this court thought he was entitled to the instruction. The second question being, and clearly, of course, and I would concede that if you were putting on the scale the credibility of the 2 competing versions of events, that you know, the heavier weight on the scale was the government's. But this is not a case where you can peer at the other verdicts. That's Roderick, that's, it's another R case, Randolph, where you say, oh, hey, you know what, he said, I was just standing out in the hall and somebody came and attacked me with a machete. And this court said, oh, wait a second, how come you were also convicted of breaking and entering into the apartment and assault and battery with a dangerous weapon on the victim's wife? This case doesn't have that. The government sort of harps on the fact, well, it was not the trifecta, but it was an exacta. It was premeditation and extreme atrocity. Well, being hoist on the court's own petard, I mean, you can't draw an inference about what that jury concluded about extreme atrocity, because they're just factors. And you know, I and all my colleagues are always here complaining about they're just factors. But you can't say, okay, they concluded it was a coup de grace. There was evidence in the case that this poor gentleman was conscious for some 4 or 5. I mean, people said it took 45 minutes.
But how many times was he shot? He was shot once and then twice in the back at close range, right?
Well, the close range I would debate.
was
But
lying
and you
on
know
the
what? I
ground.
think
He was lying on the ground when he was shot twice in the back. At least maybe I'm misunderstanding the fact.
that's their case. Mr. Johnson's case was, I just fired wildly 3 times. And yes, you know, one of the angles would suggest someone who was prone and some.
I mean, that's extreme atrocity or cruelty for sure.
Well,
no.
You know what? No offense, but you're not a juror, and I think that it would be inappropriate in this setting to say, well, it absolutely, categorically must in every circumstance.
But they found extreme atrocity and cruelty.
But they did, absolutely.
And that's one of that overuse of force in that respect is certainly one of the factors they're told to consider.
As is conscious suffering. But you don't know because there's no checklist, which, again, you know, that argument has been made and rejected umpteen times, not just by me, but by everyone else.
But if you get past the new and substantial hurdle, I gather there was no objection made to this instruction
At the trial.
at trial. So we're in a miscarriage of justice issue, whether there's a substantial likelihood of miscarriage of justice. So it's not really a matter of simply being a 13th juror. It's evaluating whether or not we consider it to be a substantial likelihood of miscarriage.
And I guess I have 3 responses to that. The first is you know, likelihood, substantial risk. I'll concede it's a substantial risk, although I'm yet to read the case that says, well, if this were a likelihood standard, we'd find it one way. If it's more a
So you're
breadth.
saying it's a substantial risk and not likelihood? Is that what you're saying?
Well, I don't see how I can make I mean, it's a motion for new trial, and
Right.
you know, I understand all of the language that's out there about how likelihood is somehow different, but to me,
Hugely different.
Talk about a metaphysical question.
Yeah.
in any event, in response, of course, I've now forgotten the question. I did get out.
Well, the question
The question is whether or not it rises to the level of a substantial risk.
And what I would and again, the government makes a big issue. Well, this is not an appeal; it's an appeal from a motion for new trial. You know what? At least half of those cases were decided in the appeals court. There's second-degree murder cases where it was a substantial risk on Acevedo errors. 3 or 4 of the, well, not 3 or 4, 2 or 3 of the SJC cases were second-degree cases that were substantial risk. And so I don't think that if there's an Achilles heel, it's that was identified by Justice Cordy, that somehow you can say, as a matter of law, that firing a gun 3 times, and that's really all the evidence is that it was fired 3 times, that there isn't a debate about, is extreme atrocity. And I would submit that you can't reach that conclusion. There was like an ABDW pendant, but it was nalprost before the case went to the jury. So you can't reach those conclusions that they absolutely rejected Mr. Johnson's story, not because they didn't believe it, but because the judge's instructions. And finally, as I notice my time wanes, I do want to point out that context is everything, as this court frequently reminds us. And I think that as you review the instruction, you'll find that there's nothing that saves it in any way, shape, or form, and would also remind the court that, again, in the LePage case, it was the appeals court, I think, in a case called Rodriguez, saying, well, the Commonwealth has the burden of proof. You can say it umpteen million times. That's not what the problem is. The problem is that the burden of proof was assigned to the wrong proposition. On behalf of Mr. Johnson, on behalf of his family, I appreciate the court's attention. Thank you.
Thank you.
May it please the court, I'm Jane Montori, an assistant district attorney from Hampden County, representing the Commonwealth in this case. And we've heard about Robert Frost, metaphysics, and horse racing, so I don't have much left to stun you with.
But can I ask you this? If this case were here today, let's assume no objection at trial, but we're here before us today, what would we do?
The outcome would be the same, Your Honor. It would be here as a first-degree murder case, so the standard of review would be substantial likelihood of a miscarriage of justice. And when the instructions in this case are viewed as a whole, and when the factors that this court and the appeals court have considered in determining whether an Acevedo error requires reversal, there are none of those factors here. The jury never expressed any confusion about murder and manslaughter. There was no instruction in this case that all instructions are to be accorded equal weight. And when the instructions are viewed in their entirety, as the motion judge in this case found, it was absolutely clear that the Commonwealth had the burden of proving beyond a reasonable doubt that the victim in this case was not the aggressor, in addition to having to prove beyond a reasonable doubt all the elements of the crime, including malice.
Could I just a slight factual question in those instructions. Justice Freed says that 2 times there's the error, but 2 times there was a correct instruction on this Acevedo question. That's not correct, is it?
I don't believe it is, Your Honor. I only found 1 time
And then it has-
explicitly mentioning the correct burden.
But then it has that incorrect language at the end of that particular paragraph, right? In other words, Mr. Stevenson says
I don't concede that that's incorrect. I think about the
that
causation.
you have to show a causal relationship between the, it sounds like the burden's back on the Commonwealth to prove that, to prove the mitigating factor, I thought. That's how I read it.
Well, I don't think it's clear what it means, but I think when you look at the instructions as a whole, that it was very clear that the Commonwealth had the burden to prove beyond a reasonable doubt all of the elements of the crimes, that the defendant was presumed innocent, and that between that instruction and the self-defense instruction, and again, the court pointed out that it was at the beginning of the murder charge where the judge indicated that the Commonwealth had the burden of proving that the defendant did not act in self-defense, and that may not have been the best place for that. But again, it was, the court found that there was no substantial likelihood of a miscarriage of justice.
Let me ask you a variation of the question asked by Justice Cordy. Let's assume the case was before us today, and let's assume there was a decision by us which said exactly what the decision there then did by Justice Freed, and we got it wrong. We said the claim was that there was an Acevedo error, and rather than addressing whether or not the Acevedo error created a miscarriage of justice, we said, no, the judge twice told the jury the burden fell on the prosecution, and therefore there was no error here. Motion for reconsideration. Do you oppose it?
A motion for reconsideration in this court?
Yes. The argument being you never really, because you're factually wrong, you never actually addressed the defense issue, because you got it, you just made a factual mistake and therefore never addressed the issue.
I would oppose it on the grounds that, again, as legally, the court reached the right decision.
Overall.
But for the wrong reasons.
Yes, that for the wrong, well, it got a fact wrong, but again, when the instructions are viewed as a whole, it was the correct decision.
Because there was no miscarriage, or because the instructions were correct?
Because the last instruction the jury heard was correct.
The last one that said, the Commonwealth has the burden of proving beyond a reasonable doubt that the defendant did not act in the heat of passion or sudden provocation, and that there was a causal relation between any such provocation and the killing?
Yeah, well, it got the burden right on the sudden provocation.
Okay, but you
Heat
think
of
that
passion.
offsets the earlier error, which says the Commonwealth, where is it? Where it was just plain wrong. I'm trying to figure out where. Oh, in order to prove a defendant guilty of voluntary manslaughter, the Commonwealth must prove beyond a reasonable doubt that, secondly, that the defendant injured Mr. Malone as a result in the heat of passion or using excessive force in self-defense. It's one of the three elements the Commonwealth must prove to prove voluntary manslaughter. That was what he said.
And that was the Acevedo error.
Right, and you're
And
saying that
it's-
the earlier statement offset that error, and that the jury would have immediately understood from that that the judge did not mean that it indeed was an element?
That the jury would understand that the Commonwealth bore the burden of proving the lack of aggression on the part of the victim, whether it be in terms of self-defense or in terms of voluntary manslaughter. And along with that would be the malice instruction, where the Commonwealth has the burden of proving malice. But getting to the original question that's before the court, whether a defendant can, under Chapter 278-33E, can come before this court and argue that there was an error. I think that the court's recent decision in Gunter answered that by saying the statute's new and substantial test does not contemplate revisiting the decision in a capital appeal merely to reconsider issues that were decided in the direct appeal, which the defendant claims were incorrectly decided, or to entertain arguments and theories that could have been but were not previously raised by the defendant. And it's clear not only could this issue have been raised by the defendant, it was raised. And I would suggest that it was decided correctly.
If it was raised and theoretically decided incorrectly, and that's beyond dispute, is it that you get no relief?
I think if the law was settled, as it was in this case, and the court's Smith decision says that you may get no, in this case you do not get relief because there was no error, and
Let's assume error. I mean, I guess the point is, let's assume there was error and we just missed it. Happens. We just missed it, got it dead wrong.
well, then there should be a correction because that would
How's
be a
one go about it?
miscarriage of justice.
Okay, even it was raised, so it's not new.
And I think the Gunter case going on in that paragraph talks about assuring that justice was done. And in a certain case, not this one, but in some cases, that may be the situation. But it's not the situation we have here.
But you're saying that because when you look at least I think you're saying that because when you look at you would say when you look at the overall case, the instructions overall are okay, and there's not a substantial risk of a miscarriage of justice, right? I mean, in other words, you're saying it because you have looked a little bit beyond the fact that it was raised before.
Well, yes.
You lifted the curtain.
Yes.
You're saying that in some cases we can lift the curtain to peek in, but Well,
I think in
what about just
Gunter-
lifting the curtain? What about just saying, if we have this gnawing feeling that we were wrong, what's wrong with just allowing the gatekeeper petition to come through?
Nothing, and then let it go again before the court. But I think that's going to be the very unusual case, and that this case is not that case. Because not only were the instructions as a whole correct, but given the divergent theories presented by the defendant and the Commonwealth, and the jury's lack of any kind of question regarding manslaughter versus murder, that there was no risk that justice miscarried in this case. The defendant's theory was that he was, after both sides agreed that the victim, Mr. Malone, had beaten the defendant about 6 months before. The defendant claimed that the victim threatened him after that, and he was so fearful that he didn't leave his house.
But I take it you're saying that this case is not new and substantial, or this case does not raise a new and substantial question, but even if it did, it's in line with Acevedo.
Yes. It's in line with cases such as Lynch, and cases where this court has found that there was no substantial either likelihood or risk of a miscarriage of justice. Randolph is another case. And I would suggest that it's been my experience whenever there has been a gatekeeper petition that not only is it argued that the issue is not new and substantial, but then the Commonwealth goes on to argue that even if the court were to find it was new and substantial, there was no error that requires a new trial. So I think that procedure being in place protects against all but the case where there is what Gunter refers to as a miscarriage of justice. But again, in this case, given the two very divergent theories, it falls right squarely in line with cases such as Randolph, where there was no miscarriage of justice because given the jury's verdict of both deliberately premeditated murder and murder committed with extreme atrocity or cruelty, the jury did not believe the defendant's version of the facts. The defendant testified that this was the first night that he had gone out. He went to the waterfront club where he knew the victim frequented. He knew the victim's family lived near there, and he hid, but the victim confronted him, and one of his friends confronted him, and that when the victim came at him with his hands or arms extended, he fired wildly. And that was not borne out by either the ballistics evidence or the evidence of the medical examiner. According to the defendant, he fired 3 shots into the victim's chest or front. In fact, there were 2 bullet wounds that entered the victim's back. The first bullet wound was as the victim fled up the street. He took advantage of the fact that the defendant's gun malfunctioned twice and took off up Hickory Street. He was hit in the back. He fell. The defendant walked over to him and fired 2 more shots into him, one into his back and one into his front that went through his body, and the bloody projectile was found at the scene.
Is that the only way that the jury could have concluded extreme atrocity or cruelty? The defense lawyer says it could also have been with respect to the victim's conscious suffering. Took 45 minutes to die. And that you could
well,
take the
the-
defendant's version of the facts, and still because of the victim's suffering, that the jury could on that basis have concluded that there was extreme atrocity or cruelty.
I don't remember anything in the record about taking 45 minutes to die. The defendant testified he didn't remember firing the shots. There were witnesses at the scene, though, who indicated that the victim pled for his life as the defendant stood nearby, begged him not to shoot him, and the defendant then fired 2 more shots into him. So I would suggest that because these versions were so very different, and the prosecutor even pointed that out in his closing argument, that even if there was error in the instructions as a whole, then there was no miscarriage of justice in this case because, again, it falls in line with those cases that say that the jury did not believe the defendant's version of events.
Thank you.
Thank you.